Thank you very much, viewers. You are welcome. This is the Legal Forum. Brighton Davis is my name. I urge you to subscribe, and again, I urge you to share to friends so that we can all gain in this. The reason why we come out with these tutorials is because we want law students outside there to gain or to get what we have already got from this, and we want you to be at the same page. In simple terms, you to understand the topics in law, because in law we say that when I know, then I should let you know what I know, so that we can combine our efforts and we defeat it and we put it to the highest level. Now, today the topic of emphasis, it is confessions and admissions from evidence law 1. Now, when you look at evidence, it is governed by the Evidence Act, Cap 8, as I've said, and you have to understand that in many things, by proving cases or in the time when cases are being discussed on or being taken in court, they only rely on evidence. So the law of evidence is the key thing in law, as I'm going to take you through. Now, when you look at confession and admission, it's governed by the Evidence Act, as I've said, and you start from section 16 up to section 28. Now, section 16, but before that, you have to understand that in confession, it is only taken in criminal cases, but admission, it is both. So you have to put in mind. Now, section 16, for it defines admission, and it says that it is a statement, oral or written, that suggests an inference to a fact in issue or relevant fact made by a party to a case. Now, what does this mean? It means that in admission, the defendant will merely concede or state a fact which might tend to prove he's guilty. By explaining this point, it means that the defendant will merely concede the truthfulness of the fact, or give something, or say something that is taking him, I can call it that it is taking him to the crime scene, or is conceding something that is making the facts clear about the same thing. To be more brief, is that an example is when you're brought to court and you say, yes, I was there, I saw something happening. Yes, he gave me his money. I know the money. I did it. Now you are taking an admission. You admitting that yes, I did it. Now, why? Because when you see the general rule states that admission are against the party who makes them, and they should not be favor of the party who makes them. It means that the person, they just presume that that person who is taking the admission will speak out something not in favor or which is not in his interest, but something which they think that will be in favor of those people who want that evidence, that kind of evidence. So in simple way, it means that this admission are self-harming. What does it mean? That someone who is taking admission should not take them in favor of him, and should not do it because he wants to be favored, but he should always do it because it's the right thing. That's why they take it to be self-harming. Once you speak something which is against you, then they take it to be true. An example is when you say that yes, I'm the one Who did this? If you say that I'm the one killed, then they will just take it the way you have said it. Now, when you look at section 17, it gives out the categories of who can make an admission. Who can make an admission? Now, uh, statement made by the party to the proceeding. Why do I mean that? When you are in court and you make a statement, you say, yes, I'm the one. Or you make a statement that is against you, or you make any statement about something, they will take it true. Another one is the statement made by the party or the agent whom the court regards who expressly, impliedly authorized by him to make them. When you give authority to someone and at the same time the law is recognizing that person, take an example as the relationship of the agent and principal agent, and the statement made by that agent will be taken to be relevant, or it will be admissible. So in this, an example is like when the client, the statement made by the lawyer from the client or about the client, they are admissible in court because the client, the lawyer is the agent, acts by the law. The lawyer is the agent of the client, and the statement are taken to be true. Now, when you look at section 18, for it to find that the person whose position must be proved as against party a suit. Now, this comes in like when, I may give you an example, when the accident happened and the driver knocks a pedestrian, and the pedestrian is suing a certain company. Let's take an example, a bus company. Now, by proving that the other person or the driver is a worker of the company, they must be, the court must first uh, make a research over it and get to know that whom are you suing? Are you suing the right person? Is he the worker of the company? It is not just a matter of suing the company. There must be, that's why they're saying there must be proof against the party to the suit. The court must put themselves and make that get clear evidence or prove that really the person is working under the same company. Now, let's move on and see what does section 19. Now, when you look at section 19, it does not basically differ from section 18, because when you look at section 19, it talks about the admission by persons expressly referred by the party to sue. Oh, this means that getting a right from someone. Take an example where the will is stating the administrator. The administrator, uh, at any point, the administrator in charge, when the administrator makes a statement, the statement can be relied on because is under the authority. All the rights are being guaranteed from the person or from the will itself. Now, when you look at the case of Patshell versus Starford, the court held that if a person derives title from another, is affected by the admission made by prejudicers concerning that property. As I've already explained that uh, the concerns, or if you get the authority from the title, as you know, the land title or the title in title, uh, what does it say? That if you get the authority from the prejudicials concerning that property, then that person who got that already authority, uh, anything that he utters out can affect or can be like a word of consent. Now, how do we prove admission? The proof of admission, that is section 20. Now, we see that you cannot make the admission that is helping you and later use it as evidence, because we see that uh, admissions are self-harming. You cannot come out and make statements, and of which you know those statements in the later, in the long run, will help you. Take an example. If I say that if A owes rent from B, and B say that you can give me time, or you can give me time, I will pay you. Let's say he wrote the message, and at the time the landlord or A sues you, you cannot say that I paid, and of which you say give me time, I will pay. That will not be taken to the relevant, because they believe that they should be self-harming. Self-harming. They should not be in favor. You cannot just speak the statement that will help you, because it is not the matter of just making statements. So when you look at section 20 for it, when it talks about the proof of admission, they say that we prove admissions by not only taking statements that are helping you, but we take statements that looks to be self-harming, or you can call it a real statement. Now, if you say that A owes B, and B said, no, give me time, I will do it, and you find the wrong one, this one is saying no, because you are saying that I will not, I pay. Now, which means you're favoring yourself, and the general rule is they should be against the maker, and they should not be in favor of the maker. So when you look at section 21, this reminds me the best evidence rule, which talks about the oral admissions about documents. Now, oral admissions about documents, this means that a person orally cannot clearly or cannot give the best answer, and where there is a document, the document remains superior in this. Take an example. Uh, when there is when you're representing like in the court, and you're saying, it's like this and this and this, and already the law states otherwise. They will rely on the document, because the document, they believe that the documental evidence uh, is superior than oral evidence. So that's why they always tell you to rely on laws, not just when you answering questions. You only you To be very good, you have to rely on what we call the laws than relying on the uh, on argumentative work. The law first, then you you bring your idea by supporting um, your you support. Now let's look at the law of confession. Confession. Now, as a law student, as I've told you, have to differ from admission and confession. You have to understand that confession is only done at the police. It is only done in criminal cases. Why? And you have to understand that this starts from Section 23 and 28 of Evidence Act. Now, the Evidence Act does not clearly explain or does not clearly define confession, but it is propounded or it was defined in the case of Swami versus King Emperor. Swami versus King Emperor, when you look at confession, you confess, yes, I did this. You confess, you give out, you utter out the truthfulness. Now, the reason why confession uh, is taken to be superior, it's because they wanted uh, to take possession of hearsay evidence. Now, why am I saying this? Because now, in hearsay, you rely on statements made by other person. Someone said, or they said. But in confession, the accused person, the defendant, the accused person is the only person to take a confession. Now, it is you, the person being accused, to take a confession, not hearsay. In Swami versus King Emperor, this is where the deceased left home and going to pick his money from the person, pick money from the other person. But before going, he had left telling uh, uh, his friend that I'm going to pick my money. So that man, when the deceased died and the body was found in a suit and dumped somewhere. So uh, as the accused was found dead, then as the deceased was found dead, then uh, the accused was charged with murder. So at the trial, the prosecution adduced evidence of the statement which the deceased made to the witness before going to visit the accused. So the evidence was challenged as hearsay, as I have said. Now, Lord Atkin defined confession as statement made by an accused person in which he admits in terms that the offense charged against him or at any rate admits in a substance or the elements of the offense. So in this, I have said that this is where the accused person will utter out the evidence or, uh, or will challenge anything that is being told that against him. They will ask you, uh, are you the one? Can you please tell us what happened? You will tell them what happened. Can you please give us this? You speak out, they write. In simple way, you confess. And this confession is done at the police. Now, who can make a confession? But before that, Article 28 clause 2A, it says that the person is presumed innocent until proved guilty. Now, which means, yes, you are confessing, you are taking confession, but you are still a suspect. You are still a suspect. You are not guilty. You are still not guilty. You are still an innocent person. That is according to to the Article 28 to 8 of the Constitution 1995. Now, Article Section 23 clause 1, which says that a confession shall be made by a person in front of a police officer at the rank of Inspectorate of Police or Magistrate. Yes, if you are taken to the police and the person who is taking a confession from you is not a magistrate or is the person of a low rank, because here the law is saying that must be the person uh, of higher rank or the inspectorate of police of higher rank. So in Beronda versus Uganda, the confession had been made to a magistrate who was alone with the accused. So the trial judge stated that the police officer should have been present. Yes. So the court dismissed the, uh, the, the appeal. Now, what constitutes to a valid confession? What makes a confession a valid one? Now, section 24. The general rule is that the confession must be voluntary. And when you look the case of Abekanyike versus Uganda, uh, it says that where there is force, violence, threats, inducement, those all things will not amount to a confession. The confession will be invalid. Now, when you look at inducement, uh, inducement, it is where like they will technically or seduce you to speak out something. In Okello versus Uganda, the court held that confession wasn't valid and it was made under uh, inducement. What are the facts of this case? Mr. Okello uh, was told that when you speak the truth, I will automatically reduce. I will reduce the years, or I will reduce uh, the punishment. So Okello stood out and spoke out, and this didn't amount to a confession because there was inducement. There was something of making you or giving you like a deal that when you say this, I will give you this. Now, threats, meaning that someone will threaten you or use force, threat you that, you know what, when you don't tell me the truth, I may harm you. Being threatened. Now, in Mwangi, son of Joleke versus R, in this case, the police officer kept on questioning uh, the accused that even if you don't tell me, I will use it. So the accused was threatened in some way. So when you read that section 24 for it, it gives you a number. How it shows the procedures the the accused person has to follow. And in this, it was in the case of in the case of so in the case of Andre Asenua versus Uganda, in the case of Andre Asenua versus Uganda, the court highlighted the 12 procedures the accused person or the uh, to be followed, the number of rules to be followed when making a confession. In this, uh, that a person should give uh, That a confession should be written or it should be asked in a language he or she understands, that there must be two people in the room, the police officer, the person to take a confession must be the police officer of higher rank or the magistrate, and many more. So when you look at section 26, it talks about the promise of secrecy. Promise of secrecy. What does it mean? That promise of secrecy. This is explained like an example is like when uh, you are somewhere. Let's give an example that you are at the police and the police ask you about something. That if you tell me this, I will not speak it out. Then for you, go ahead, you give that thing, you tell that thing, or you tell him about that. So when the police officer writes that thing in a confession, uh, it is not admissible unless it is proven to be true in the same way. Now we have what we call repudiated and retracted. Repudiated and retracted confession. Repudiated and retracted. Retraction confession. Yes, an accused person can retract or repudiate a confession. Retraction of a confession means that, yes, uh, I admitted that I did this, but I feel like I want to challenge the truthfulness. Why? Because you may find that there were some things. Yes, I said that I killed him, but they forced me. That is retracted. Now, for repudiated, you deny the truthfulness. You say, no, I didn't say anything. I don't know about it. Now, what will the court say? What will the court do? For the court, it will conduct what we call a trial within a trial. What is a trial within a trial? A trial within a trial, they will question you uh, about, if you say yes, they threatened me to do this. They threatened me to say that I stole. Then they may ask you to come out and speak. What did you do? What happened? Then you take it. You say it. But what if they find that those things that you're speaking out are totally similar to what was written or was taken as confession? Then the confession, the higher confession, will be taken to be true. So thank you very much. Thank you for following. Thank you for watching. I salute you all. I urge you to subscribe. We are coming with many more other topics in Evidence Law 1. Jabres.